Hello, my viewers and subscribers. Welcome to another episode of Jamaica Politics Uncovered. Today, I'm going to bring you the live verdict / decision of the Privy Council as they read it in court today. Have a listen, guys.
East's murder. A fifth defendant was unanimously acquitted. Juror X was immediately arrested and was later convicted of attempting to pervert the course of justice. There was no evidence to connect his activities with the appellants. The appellants appealed against their conviction to the Court of Appeal of Jamaica, which dismissed their appeals. The Court of Appeal granted permission to appeal to the Judicial Committee of the Privy Council on 3 grounds, which were, first, that the trial judge failed properly to inquire into allegations of juror misconduct; secondly, that the trial judge departed from standard practice in inviting the jury to retire to consider their verdict so late in the day, putting undue pressure on them to reach a verdict; and thirdly, that the trial judge erred in admitting the telecommunications data because it had been obtained in breach of the Interception of Communications Act and the Charter. The Judicial Committee of the Privy Council has unanimously concluded that the appeals should be allowed and the appellant's convictions should be quashed on the ground of juror misconduct, and that the case should be remitted to the Court of Appeal of Jamaica to decide whether to order a retrial of the appellants for the murder of Clive Williams. The Board has considerable sympathy with the dilemma faced by the trial judge on the final day of a long and complex trial. Following the allegations of bribery, he had either to continue with the 11 remaining jurors or to discharge the jury. Despite this, the Board considers that the approach taken by the judge was a material irregularity in the course of the trial, which makes it necessary to quash the convictions. This is for 3 reasons. First, the direction to the jury on the final day was inadequate to save the situation. The judge simply reminded the jury that they had sworn or affirmed that they would return verdicts in accordance with the evidence they had heard in court. The judge did not refer to the alleged bribery, of which, if the allegations were true, the jurors were already aware. Secondly, the trial continued with the allegedly corrupt juror serving as one of its 11 members. In the Board's view, there should have been no question of allowing juror X to continue to serve on the jury. Allowing juror X to remain on the jury is fatal to the safety of the convictions which followed. It was an infringement of the appellant's fundamental right to a fair hearing under the Jamaican Constitution. Thirdly, the judge should have considered whether the remaining jurors might have become, consciously or unconsciously, prejudiced for or against one or more of the appellants as a result of juror X's behavior. For example, there was a danger that the attempted bribe could have made the other jurors overcompensate, consciously or unconsciously, if they assumed that the offer must have come from one of the appellants and that therefore they must be guilty. The judge took no account of this risk. The Board is very mindful of the serious consequences which may flow from having to discharge a jury shortly before the end of a long and complex criminal trial. It is also very conscious of the danger of deliberate attempts to derail criminal trials by engineering situations in which it is necessary to discharge the jury. In England and Wales, there is legislation which allows a judge in certain situations to discharge a jury because of jury tampering and to continue the trial by judge alone. There is no such legislation in Jamaica. It follows that there will be occasions where, as in this case, a court will have no alternative but to discharge a jury and end the trial in order to protect the integrity of the system of trial by jury. In view of its conclusion on the issue of juror misconduct, the Board holds that it is not necessary to express a concluded view on the other 2 grounds of appeal. For these reasons, the appellant's appeals should be allowed. The Court is now adjourned.
Yes, guys. So what do you think about this? I mean, clearly, there were some technicalities, and he read them out clearly. He said that one, the jury was basically contaminated. The second thing is they were pressured to make a decision because of time constraint. And also, they said that under Jamaica's constitution, Kartel was violated. You know, they also made mention of the privacy issue. So it would be a win, I think, for Kartel and his team. Based on what the Privy Council said, they're saying that this process was flawed. It was breached. Therefore, we cannot tell you to keep these people behind bars. You're going to have to decide how it goes. And common sense now would dictate to Jamaica that they're going to have to either let the man go or come up with a retrial. Now, this is where it gets interesting. Will Jamaica take the risk, and I do consider it a risk, will they take the risk to let a retrial take course? And if so, who is at an advantage and at a disadvantage? It is possible that they may do a retrial. And because, remember, you know, there is no blame to be placed on the DPP. Let's make that clear. The blame, and as the gentleman said, he empathizes with the judge who presided over the case. It was high profile, tensions high, all of this. But the DPP did nothing wrong. The onus is on the judge who presided over the case, right? Because all of them, there's something there with the juror, where them should have let back in there. You know, the privacy issue, and also, you know, the other technicality that was mentioned. This is all on the judge. The prosecutor brought their case, and, you know, the judge has the final say, who's presiding over the case. Now, how will the state proceed now? I imagine the prosecution, they're having their meetings and they're trying to figure out where to go from here. And if they should say, let's just do a retrial, they would be within their right to do so. And it could work out to Kartel's favor, because the people them will come and testify and they're sitting there. If them not come back and testify, then you know that problem that for the state again. You understand? So we'll see what happens. Should Kartel be feeling really good right now? I don't know. I mean, he should feel good knowing that, you know, his lawyers who brought to the court, to the Privy Council's attention about the technicalities and so on, his lawyers won. Yes, they did. But did Kartel win? I mean, 10 years in prison and his health deteriorating. Why didn't they bring this to Privy Council much sooner? You know, these are all the things, but we'll see what happens going forward and how the state decides to handle it, because I don't know if, you know, physically and emotionally, Kartel could go through a retrial. Like I told you guys before, I thought that based on how the system in foreign countries work, them not work with technicalities when time it come on to people freedom and people life, them not going to work with it. And as I said, he will be free. I told you guys that, you know, the day of the hearing. And right now, I am going to tell you that I don't believe that Jamaica will put Kartel back on trial and his co-accused. I don't think they're going to do it. But we will see how it will be handled going forward. Because what is happening here is that they are putting the ball back in Jamaica's court, no pun intended, in terms of the appellate court. So they're going to have to decide now about a retrial and all these things. So guys, let me know what you're thinking in the comment. And make sure to share the content over here. Make sure you are subscribed. You have your notification on, and I will catch you in the next video.